Thank you. I'll speak on amendments number 5, 7, 9, 10 and 11 and this section, and I'll come back in after on amendments 36 and 38, if you don't mind. Thank you. Well, they're all being discussed together, but it's quite a long list of amendments that I have, so I want to try and get in as many as I can. So in Amendment 5, the current definition of hatred that exists is too loose, Minister. The current definition gives too much power to the Gardaí, the DPP and the judiciary. If it came to something like the trans issue, a person could be convicted whether they are favourably disposed to transgender views or opposed to them. A rigorous definition of the concept of hatred, as utilised in this bill, is essential for the sake of public interest and legislative clarity. The burden of proof for hate refers to the legal standard or threshold that must be met to prove that an act was motivated by hatred in cases involving hate crimes, hate speech or hate-related offences. This burden of proof is a crucial aspect of law enforcement and judicial processes, as it determines whether or not the accused can be held legally responsible for actions deemed to be motivated by hate. Key aspects of the burden of proof in hate crimes or hate speech include, but are not limited to, proving motivation. One of the main challenges in hate crime or hate speech cases is proving that the motivation behind the act was hate based on characteristics like race, religion, ethnicity, gender, sexual orientation or disability that distinguishes the act from regular criminal activity. The prosecution must show that the defendant's actions were not just illegal in cases like assault or vandalism or verbal abuse, but that these actions were explicitly motivated by bias or prejudice against a protected characteristic of the victim. The standard of proof. In criminal cases, including hate crimes, the burden of proof is typically beyond a reasonable doubt. This means that the prosecution must convince the court or jury that the accused committed the crime and that it was motivated by hate to a very high degree of certainty. In civil cases, such as cases involving discrimination or hate speech, the standard of proof is often on the balance of probabilities. This lower standard requires that it is more likely than not that the action was motivated by hate. However, this poses a dangerous threat to fairness in our justice system. Evaluating the probability that a statement is defined as hate speech injects an arbitrary and an opinionated procedure into our courts, as the government have chosen not to define the meaning of hatred for the purpose of this bill. Evidence of hate or bias. To meet the burden of proof in hate crime cases, prosecutors must present evidence showing that the act was motivated by hate or bias. This can include direct evidence, statements made by the perpetrator during or before the crime, such as the use of racial slurs, homophobic language, or symbols associated with hate. Circumstantial evidence, evidence that suggests that crime was motivated by hate, such as targeting a place of worship, a specific ethnic group, or an LGBTQ+ establishment. History of behaviour. If the accused has a documented history of biased hate speech or participation in hate groups, this may be presented as evidence of motivation. Proving hate in court. Courts often require clear and convincing evidence that bias or hatred was a substantial motivating factor behind the defendant's action. Intent is critical. Hate crimes are considered crimes of intent, meaning that the prosecution must show that the accused intentionally targeted the victim based on a characteristic such as race, religion, or sexual orientation. The challenges in proving hate Subjectivity of motive can be difficult to definitively prove what was going on in the perpetrator's mind when they committed the offence, especially if there was no overt statement or symbol of hate. Mixed motives in some cases, the accused may have multiple motivations for their actions, not all of which involve hate. For example, a robbery that also involved racial slurs might raise questions about whether the hate component was the primary motivating factor. Free speech protections in hate speech cases. The burden of proof must also balance legal protections for freedom of expression. Courts may require a high threshold of proof to determine that the speech was incitement to violence or hatred, rather than merely offensive or controversial. The burden of proof for hate crimes in demonstrating that the accused's actions were motivated by hate, bias, or prejudice against a protected characteristic. This can involve proving intent through direct statements, historical behaviour, or other circumstantial evidence. The standard of proof in criminal cases, beyond a reasonable doubt, is quite high, making these cases challenging, especially in determining motivation. Adopting a precisely crafted and transparent definition of hate for the purpose of this legislation is essential to minimise and prevent improper convictions of people who have not called for physical harm to others, but whose comments could be punished unjustly by this law. The government must not merely proclaim protected characteristics, as done so vaguely in this law, as necessary for state protection, while obscuring from the public any definition of what actions are considered criminal under this legislation. The state ought to provide an extensive list for each protected characteristic, outlining sample statements and hypothetical cases in which it is extremely clear to the public what kinds of statements are to be criminalised under this bill. Amendment 7. This bill lacks the definition of hate, but it also lacks what incitement to hatred or incitement to violence actually is. This amendment...
From the bill, it's being removed. We're not.
Sorry?
It's being removed.
I've already tabled my amendment, so I'm afraid, Minister, you're going to have to listen to this. The amendment may aim to address this issue and ensure that there is a threshold.
For everybody's benefit, including your own, if the section is already being opposed,
well,
there's no need to talk to it.
I'm speaking on amendment number 7, which is included in this section. All right? Thank you.
But it's being deleted.
It hasn't yet been deleted.
Well,
sorry.
I understand what you're doing.
I actually didn't interrupt anybody in any of the contributions
I know
earlier
that.
on. And
I'm just saying, for your own, I think to be fair to the Minister, I think she was trying to be helpful.
Okay. The bill currently lacks a clear definition of hate and incitement to hate or incitement to violence, which are central to its purpose. By leaving these terms undefined, the legislation risks creating ambiguity in its application, leading to potential challenges in enforcement, interpretation and legal scrutiny. This amendment seeks to address this gap by providing a clear and precise definition of incite, violence or hatred as conduct specifically intended to cause physical violence or create intense or irrational emotions of opprobrium, extreme disapproval, enemy, hostility or detestation, hate towards a person or a group. Incorporating these thresholds ensures that the legislation targets conduct that goes beyond mere expressions of disagreement or distaste and focuses on speech or actions that genuinely aim to incite harmful emotions or actions against others. It protects the fundamental rights to freedom of expression while drawing a firm line around behaviours that threatens societal peace and individual safety. Incitement refers to encouraging or provoking someone to commit a crime or act unlawfully. In the context of this bill, incitement to violence or hatred involves actively commanding or encouraging others to commit violent acts or to develop a strong, unjustifiable bias or hatred towards individuals or groups based on characteristics like race, religion, sexual orientation or gender identity. The inclusion of this definition sets an important legal standard that can help distinguish between legally protected forms of speech and conduct that seeks to provoke violence or irrational hostility, ensuring the law is both effective and proportionate. Globally, many legal frameworks include clear and well-defined parameters for what constitutes incitement to hatred, ensuring that legislation can be applied consistently and fairly. For example, the International Covenant of Civil and Political Rights, the ICCPR, in Article 20, Section 2, defines incitement to hatred as speech that advocates for national, racial or religious hatred that constitutes incitement to discrimination, hostility or violence. The ICCPR's guidance stresses that restrictions on speech must be necessary and proportionate to prevent overreach. The Council of Europe, in its additional protocol to the Convention on Cybercrime 2003, defines incitement to hatred as the act of spreading racist and xenophobic material, which is motivated by hostility or prejudice and likely to incite violence or discrimination. The European Union Framework Decision on Combating Racism and Xenophobia 2008 also defines incitement to hatred as the public dissemination of message that incite violence or hatred based on race, colour, religion or descent, again focusing on clear intent and specific targeting. These international legal standards provide robust, narrow definitions to prevent both misuse of the laws and the risk of infringing on freedom of expression. They also emphasise that incitement laws must address speech or conduct that genuinely threatens public safety or leads to real-world harm, ensuring that law focuses on actions with clear intent to incite violence or hatred. The current bill, however, lacks any such clear or precise definition for what constitutes incitement to hatred or incitement to violence. Without a concrete framework, the legal threshold for conviction may be uncertain, leaving critical questions unanswered. What level of conduct or speech would trigger an accusation or conviction? How will the courts distinguish between heated or offensive speech and speech that actually incites violence or hatred? This absence of clarity may lead to subjective interpretations of what constitutes incitement, increasing the risk of inconsistent enforcement. The lack of an explicit definition creates potential for overreach, where individuals may be prosecuted for speech that, while offensive or controversial, does not rise to the level of incitement under international human rights standards. Without a clear legal definition of incitement, individuals could be wrongly convicted based on misinterpretation of their speech or intent, where provocative, controversial or critical statements are seen as incitement, even when they fall short of encouraging actual violence or hatred. Vague or subjective standards where authorities or courts apply inconsistent criteria, potentially leading to the prosecution of speech that is merely offensive, distasteful or descending rather than incitement. For example, an artist, journalist or an activist expressing views critical of a political group or religious ideology could be charged with incitement of hatred under a broad or ambiguous law, despite having no intent to provoke violence or irrational hostility. This would have a chilling effect on free speech, discouraging individuals from expressing legitimate, though controversial, opinions. Moreover, the lack of definition may cause disproportionate enforcement against minority groups, dissidents or marginalised communities who may be more vulnerable to accusations of incitement due to cultural misunderstandings or political bias. In its current form, the bill risks violating international norms on free expression by failing to provide clear definitions for incitement to hatred or incitement to violence. The proposed amendments seek to introduce a clear and specific threshold for incitement, ensuring that only conduct with the intent to provoke violence or irrational hatred is criminalised. This will protect the fundamental right to free speech while ensuring that the law effectively addresses harmful conduct aimed at inciting violence or hatred. By drawing on international legal standards, this amendment ensures that the bill aligns with best practice, maintaining a balance between the right to freedom of expression and the need to protect individuals from genuine threats of violence and hate. The absence of a clear definition for incitement to hate within the current bill also poses broader implications for legal certainty. Internationally, legal certainty is a fundamental principle of the rule of law, ensuring that individuals can understand what actions are prohibited and adjust their behaviour accordingly. By failing to provide precise language around what constitutes incitement to hatred or violence, this bill risks creating ambiguity in its enforcement. Without a clear definition, ordinary citizens may not know when their words or actions could cross the line into criminal conduct. This creates an atmosphere of fear and uncertainty around the boundaries of permissible speech. As seen in other jurisdictions, such uncertainty can result in self-censorship, where individuals avoid expressing opinions that, while lawful, could be perceived as incitement. This disproportionate affects public discourse on controversial issues, especially political, religious or social matters. Law enforcement agencies tasked with applying the law may struggle with how to interpret vague provisions, leading to inconsistent or biased enforcement. This can result in selective prosecutions or targeting of individuals or groups based on subjective judgments rather than objective legal standards. As demonstrated in jurisdictions where similar laws lack clear thresholds, officers may find themselves uncertain about what exactly constitutes incitement to hatred versus offensive or provocative language that remains protected under free expression rights. The courts may be burdened with the complex task of interpreting these vague provisions, leading to varying judgments across different cases. This can create legal inconsistencies, as different judges could apply the law based on their personal interpretations or societal attitudes. A lack of clear criteria could open the door to broad judicial discretion, which increases the risk of legal rulings being influenced by political or cultural biases, furthering complicated matters of free speech and protection against genuine incitement. International law cases demonstrate that minorities and marginalised groups may be disproportionately affected by hate crime legislation that lacks specificity. These groups may be unfairly targeted or accused of incitement when expressing views that challenge the majority, leading to a skewed application of justice. In countries where broad or ill-defined incitement laws exist, activists from minority communities have often found themselves criminalised for raising critical or uncomfortable discussions about social injustices, despite having no intent to incite violence or hatred. The proposed amendment seeks to prevent wrongful convictions by demanding a clear threshold for what constitutes incitement to hatred or violence. When the law is unclear, it opens the door to misinterpretation and misuse, particularly in cases where speech is misunderstood or misrepresented by others. This is especially true in highly charged social or political contexts, where emotions run high and legitimate criticisms or dissent can be misconstrued as hateful or violent incitement. Without specific definitions and legal criteria, individuals could face charges based on subjective interpretations for their intent or statements. For example, a public figure or speaker engaged in controversial political debate could be prosecuted if their statements are seen as hostile, even if they did not intend to incite violence or hatred. Satirical speech or artistic expression, which often uses exaggeration or provocation to highlight societal issues, could be wrongly viewed as incitement due to the subjective reactions of audiences. The lack of a clear intent requires also leaves the law vulnerable to being weaponised against individuals or groups for reasons unrelated to genuine incitement. This could lead to a chilling effect, particularly in relation to sensitive or polarising topics such as religion, gender identity or ethnic relations, where accusations of hatred or violence may arise from misunderstandings rather than actual malice. The proposed amendment aims to bring the bill in line with international standards, which typically include clear intent and specific harm as necessary components of any hate speech or incitement law. For instance, the Rabat Plan of Action, the UN High Commissioner of Human Rights 2012, outlines 6 key factors to consider when determining whether speech constitutes incitement, including intent, context, and likelihood of harm. These guidelines underscore the need for a high threshold to ensure that restrictions on free speech do not exceed what is necessary to prevent violence or discrimination. The European Court of Human Rights has consistently ruled that restrictions on free speech must be carefully balanced to ensure that they do not infringe upon the rights of freedom of expression. This includes a focus on whether speech directly incites violence or discrimination. By introducing a clear and specific definition of incitement to hatred and violence, the amendment would ensure that the bill meets these internationally recognised standards, reducing the risk of overreach or misapplication. The proposed amendment is critical for ensuring that the bill provides clear definitions and a high threshold for what constitutes incitement to hatred or violence. Without such clarity, the bill risks creating legal uncertainty, chilling free expression, and leading to wrongful convictions based on vague or subjective interpretations of intent. By aligning with international norms and providing specific guidance on incitement, this amendment would help safeguard both public safety and the fundamental right to free expression. Excuse me. Amendment 9. The definition aligns the definition with Irish law. But if we are to accept the government's definition, this would mean there would be at least 72 genders, which could include, but are not limited to, agender, ambigender, adamasgender, aerogender, anisogender, affectogender, agender flux, alexigender, aliasgender, amergender, ambigender, ambonec, amnicagender, amoragender, endocrine, endocrine flux, anisogender, angel gender, anogender, anon-gender, antisgender, annexgender, apangender, apconscrewgender, apertusgender, apusgender, aquagender, aquariusgender, archigender, argogender, aristogender, arithgender, artistigender, astroflux, astrogender, atmosgender, arturgender, atugigender, autogender, axigender, axiogender.
The word is, sorry. Help us gender. Sorry. I thought he was raising a point of order.
Oh, sorry, okay. Bafflegender, bakergender, biogender, blissgender, blurgender, boggender, bordagender, boyflux, brevigender, burstgender, cadisgender, kalegender, cansegender, canisgender, cantogender, caprigender, cartogender, casflux, cavusgender, cisgender, celisgender, gendergender, centrigender, servogender, chaosgender, circgender, circumgender, clarigender, cloud gender, clown gender, code gender, cognito gender, coal gender, call gender, com gender, comp gender, compose gender, congru gender, constel gender, conti gender, contin gender, coru gender, cosmic gender, cosmi gender, comulog gender, cyan gender, silo gender, and I must, please forgive me if I do pronounce some of these wrong. They're quite extensive, and if I do offend anybody in reading this out and making mistakes, I apologise.
If I may just
Damn
give
gender.
could I just stop you just for 1 second,
Yes.
just to give you a breather?
Thank
Could
you.
I just welcome our former colleague and friend, Shannon Neil Brunacon, to the public gallery. Neil, it's good to see you. Very welcome to Leinster House. Thank you for being here. Keep me the Sorry, Senator Keogan.
Thank you very much. Comp gender, compost gender, congru gender, constant gender, conti gender, contin gender, cora gender, cosmic gender, cyan gender, cyclogender, dal gender, damp gender, days gender, delta gender, demi-gender, demi-fluid, demi-boy, demi-girl, demi-bi, demi-flux, demos gender, denantine gender, dentro gender, depressed gender, deserved gender, design gender, devised gender, divine gender, demi-on gender, dream gender, deluxe gender, dust gender, disophoric gender, endopho gender, ego gender, e-gender, eclipse gender, effort gender, elgrin gender, L gender, emmet gender, elex gender, effus gender, ember gender, N gender, N genipe gender, N lobe gender, E gender, intus gender, endromo gender, eno gender, epic gender, epigender, equil gender, evapor gender, evoke gender, ex gender, expand gender, expect gender, exter gender, extract gender, fabric gender, fact gender, faddy gender, fe gender, fawn gender, fawn agender, phas ogender, fellas gender, femi gender, femi fluid, fem gender, fluis gender, flu gender, fic gender, fire gender, flam gender, flash gender, fluor gender, flexi gender, flicker gender, fling gender, flow gender, fluid trogender, fluid jetrosexual, fluid ender, flux fluid, flux gender, fluxion gender, foam gender, flow gender, font gender, foreigner, forno gender, fraggin gender, flan gender, fran gender, frick gender, frigid gender, frond gender, frost gender, fruity gender, fugu gender, glacky gender, gale gender, gallon gender, gallop gender, gender flux, gender fluid, gender light, gender satyr, gender sea, gender wood, gender, genic gender, geogender, low gender, gerund gender, giggle gender, glacy gender, glisten gender, glick gender, gloom gender, glossogender, glow gender, glue gender, gringe gender, grit gender, guaran gender, guas gender, gull gender, gunny gender, gust gender, gene fluid, gynogender, gyn S gender, haggy gender, Hayden gender, hallow gender. Sorry. Hallow gender. Hapslow gender, Hassan gender, Havo gender, heel gender, heart gender, head gender, heli gender, hemi gender, hexagender, hydrogender, hyma gender, hippo gender, hora gender, hollow gender, hora gender, horse gender, host gender, whom gender, hurricane gender, hydrogender, hydranger, hype gender, hyperger, hypergender, icongender, imbergender, emogender, impulsi-gender, inagender, indagender, indio-gender, infinity-gender, insig-gender, intelligender, intergender, interflux, Isaac-gender, iris-gender, isogender, intergender, intinogender, itzy-gender, Janyo-gender, Jenga-gender, Juscus-gender, Jordan-gender, Junk-gender, Jupiter-gender, Just-gender, Kaleido-gender, Kaleidoflux, Calogender, Kepler-gender, Kerfuffle-flux, Kenique-gender, Kiss-gender, Chlorgender, Corogender, Cryptogender, Corogender, Latonic gender, Lagan gender, Lamin gender, Lampad gender, Lampus gender, Latic, Latin gender, Lavender gender, Lentis gender, Leo gender, Lepin gender, Listen gender, Living gender, Locus gender, Logic gender, Log gender, Loop gender, Lotic gender, Lounge gender, Lugan gender, Lumming gender, Luna Lo gender, Lunar gender, Lurgig ender, Luster gender, Lux gender, Magro gender, Magno gender, Magpie gender, Magno gender, Majest gender, Mago gender, Malu gender, Maple gender, Marin gender, Marin Gun gender, Marvel o gender, Mass gender, Mason gender, Matic gender, Maxi gender, Meand gender, Me Chan gender, Medi N gender, Medley gender, Melaco gender, Meli gender, Mel Odi gender, Mimi gender, Ment Te gender, Merkel gender, mesogender, metamorph o gender, microgender, misdias gender, maya gender, myage gender, mimo gender, molt gender.
On a point of order, please.
The Senator trying to make the point that the number of genders is infinite, in which case we may be here for a very long time.
Thank you.
Well, I think there's
Really
just
a point
about...
of order,
well,
but
I think it's
relevant
important.
question at the same time, but not a point of order, but thank you for raising
Yeah.
the matter.
I think it's important that we know then what the words gender mean. Does it mean these particular genders? And I think
You're reading
this is
out.
important to read them into the record of the House.
It's not a very good use of time.
It may not be, but this is a really
In the
important
context
piece
of it,
legislation.
I know,
Sorry.
I know it is. I know it is.
Senator,
But in the context of a
Senator
guillotine-
Walker, thank you. Could we address our remarks to the Chair, and could we keep our remarks to the relevance of the bill and to the amendment and to the issues being raised? And I would remind members that in the context of the amendment we're on, the relevance of the amendment is about the definition and
Gender, yeah.
let's stick to that, please.
Point of order.
Point of order, Senator Clooney. Sorry, go
I
ahead.
just want to say, and again, with respect, Senator, it's not a comprehensive list, because all of humanity is infinite and varietal, and all difference is to be celebrated. And
Not really a point of order, but...
So it's a finite list, so it can't purport to represent the infinite variety of all human beings, which I say should be celebrated.
Thank you.
Microgender, medisgender, migender, migrogender, memogender, moltgender, momentigender, monigender, mooncangender, morphogender, mossgender, montigender, mountain gender, mauve ender, multigender, mundang gender, monk gender, muran gender, musis gender, mute gender, myo gender, nap gender, narrow theo gender, ni bulan gender, ni fast gender, neo gender, negli gender, nimmer gender, Neptune gender, nervy gender, netro gender, next gender, nico gender, night gender, nebus gender, knock gender, nobi gender, non-binary, non-gen gender, non-gi gender, novas gender, null gender, numeri gender, nox gender, nitro gender, os gender, oblique gender, nu v gender, oclu gender, order gender, off gender, omega gender, omni gender, omnis gender, omniver gender, omni-move gender, orni gender, ortho gender, obgender, opaque gender, oplas gender, open gender, opigender, opulence gender, opus gender, obis gender, orchi gender, orchi gender, orogender, or oregan gender, oscillate gender, omas gender, overcast gender, ovo gender, ox gender, oxto gender, os gender, passy gender, paddin gender, palo gender, pamiflux, pamlo gender, panarchic gender, pander gender, pand gender, pans x gender, paragender, palogender, parasole gender, parch gender, partic gender, pas gender, parta gender, pegas gender, pel-gen gender, perennial gender, perigender, permi-mono gender, permagender, perigender, persecuto gender, persophono gender, petrogender, phantom gender, phlegm gender, photogender, phototropo gender, furrow gender, piano gender, pic gender, piata gender, pigeon gender, pink gender, pio gender, pixie gender, plasma gender, platogender, platogender, please gender, plio gender, Pluto gender, poetry gender, polar gender, polaris gender, polysflux gender, positivo gender, pos gender, pote gender, prairie gender, precaric gender, precipi gender, permi gender, prima gender, priva gender, probabil gender, prod e gender, prodmo gender, profect gender, progin e gender, proliflux, propagender, prospic gender, protogender, purgogender, pyrogender, quasi-gender, quest-gender, quiet gender, quintigender, quinx gender, ray gender, radiant gender, rainflux, rainogender, rapporteur gender, raven gender, ray gender, rayon gender, ready gender, realm gender, recurry gender, reflexogender, regender, regic gender, re-engender, relic gender, religender, reignite gender, repentagender, respigender, restitute gender, retrogender, revigender, riva gender, rex gender, rithema gender, rima gender, riptide gender, rishi gender, Reven gender, river gender, Rowan gender, robot gender, Roku gender, Rocky gender, Ro gender, romantic gender, Rosa gender, Rose gender, Rotund gender, Ruby gender, Ruinger gender, Rust gender, Rush gender, Sable gender, Sakel gender, Safe gender, Saget gender, Sagittarius gender, Savo gender, Samo gender, Saddlewood gender, Sand gender, Sandagender, Santi gender, Sap flux, Sap gender, Saf gender, Salcher gender, central gender, centre gender, suck gender, see gender, sealude gender, sedata gender, self-figurenda, censor gender, sensio gender, cpia gender, sequio gender, serano gender, sap gender, char gender, shatter gender, shift gender, shift fluid, shift gender, shimmer gender, ship gender, shoal o gender, shoe gender, shy gender, siam gender, sibi gender, sick gender, psi gender, sigma gender, silan gender, silo co-gender, silk gender, simula gender, singo gender, singularity gender, sinister gender, siren gender, six gender, skate gender, skellig gender, sky gender, sky lar gender, sleep gender, slide gender, slog gender, slush gender, smar o gender, smile gender, smogender, smoke gender, snow gender, soft gender, solar gender, solemn gender, solid gender, silo gender, slovo gender, solun gender, somni gender, soan gender, sonic gender, soan gender, soup gender, sound gender, speed gender, spic gender, spillinger, spirit gender, splash gender, splendor gender, spook gender, spray gender, spring gender, sprite gender, spritz gender, spur gender, squall gender, squawk gender, squeal gender, straddle gender, stage gender, stalic gender, stalagmite gender, starlight gender, star gender, static gender, stellar agender, stellar gender, stern gender, still gender, storm gender, stovo gender, stratagender, stream gender, street gender, strict gender, strobio gender, strut gender, slub flu, subgender, subdue gender, subri gender, subterran gender, successor gender, subgender, sunrise gender, sunset gender, super gender, superflux, supreme gender, supergender, surf gender, surprise gender, seren gender, swarm gender, swelter gender, switch gender, sword gender, sky by gender, synergy gender, synod gender, siren gender, cysto gender, taboo gender, tadpole gender, tailor gender, talum gender, tar gender, tassel gender, tech fluid, tech gender, tempest gender, temple flux, temporal gender, tenebro gender, tension gender, tent gender, ter gender, terran gender, tesser gender, tessie gender, texture gender, taslo gender, thaw gender, thermoflux, thermogender, thistle gender, thorough gender, thought gender, thread gender, thrilly gender, thrump gender, thunder gender, tidal gender, tide gender, tyo gender, tie gender, tiger gender, tilt gender, time gender, turno dog gender, touch gender, tower gender, trace gender, traffic gender, transgender, queer, transient gender, transit triangle gender, tricus gender, trident gender, triform gender, trilix gender, throt gender, troubadour gender, tro gender, trumpet gender, trucks gender, tsunami gender, turbo gender, turntable gender, tute gender, twig gender, twirl gender, Twitter gender, twilight gender, twinkle gender, twinkle len gender, type gender, typo gender, tiro gender, ultra gender, gender, umbrella gender, you me be big gender, you arrow gender, you binary, you blurred gender, you clo gender, underflux, under gender, underflow gender, uniform gender, union o gender, unique fluid, unique no gender, no gender, gender, unsung gender, gender, updrafted gender, uplift gender, upper O gender, urano gender, Eurogo gender, urano gender, Euro gender, Uras gender, Usher gender, Utapan gender, Utensi gender, Utopian gender, Vacat gender, Vagander, Vagabond gender, Vague gender, Valency gender, Valley gender, Valen gender, Van gender, Vary gender, V gender, Velocity gender, Veil gender, Velum gender, Velvet gender, Venander gender, Dio gender, Venus gender, verb flu, verb gender, versato gender, vesp gender, vibrata gender, victor gender, verti gender, vertender gender, villain gender, vine gender, viola flux, viola gender, virtue gender, vision gender, vita gender, vital gender, void gender, volta gender, volt gender, voyage gender, vocal gender, whale gender, warringer, war gender, wedge gender, welcome gender, whisper gender, whist gender, white gender, willow gender, wind gender, window gender, windy flux, winter gender, wobble gender, wooden gender, work gender, woven gender, rat gender, reno gender, ringer gender, exang gender, XME gender, XO gender, exograph gender, extra gender, exilo gender, exilo ender, yarno gender, yono gender, yearn ing gender, yellow gender, yield ender, yo e ender, young gender, youth gender, yitter, big ender, zypho gender, zero gender, zigzag ender, zo d ender, zo gender, so engender, zoom gender, XY gender, and asilo gender. It's worth noting that if you were to accept our amendments today, you might avoid the possibility of a constitutional referendum later down the road. On amendment number 10, the amendment proposes a specific definition of hate to be inserted into the bill, framing it as a malicious attempt to victimise an individual or group based on their protected characteristics. This victimisation must be likely to entice another person to commit an act of discrimination or violence. The current draft of the bill lacks such a definition, which creates significant concerns regarding legal certainty and clarity in its enforcement. As noted in Minister McEntee's statements, it has been implied that we all know what hate is. However, without a concrete and legal definition of hate in this bill, there is a risk that both law enforcement and the courts will struggle to apply the legal legislation consistently. This could lead to uncertainty and arbitrary enforcement, where accusations of hate are made based on subjective interpretations or social context rather than clearly defined legal standards. The proposed definition ensures that a threshold is established for what constitutes hate, by specifying that hate must involve a malicious intent to target individuals or groups based on the protected characteristic. This definition sets A, standards of what type of behaviour or speech qualifies as hate, requires a clear connection between the hateful act and its capacity to entice discrimination or violence. This ensures that only actions or expressions with real-world harm consequences would be subject to legal consequences, protecting free expression while addressing genuine harm. Globally, incitement laws must balance freedom of speech with the need to prevent violence and discrimination. Several international legal frameworks and instruments have addressed the threshold for incitement. The European Court of Human Rights has emphasised that speech restriction must be narrowly defined and only enforced where there is a clear intention to incite violence or hatred that leads to discrimination. In cases where speech merely offends or shocks, is it protected under free expression rights? The United Nations Rabat Plan of Action outlines a high threshold for what constitutes incitement, requiring that the speech in question must be directed at the audience, have intent to incite, and be likely to lead to imminent harm, such as discrimination or violence. This approach seeks to distinguish between lawful speech, even if provocative, and unlawful incitement. By providing a definition of hate, this amendment aligns with these international principles, ensuring that the law only targets behaviour or speech that is genuinely harmful. Without a specific definition, there is a risk of wrongful convictions under this bill. Speech that is critical, controversial or uncomfortable could be wrongly perceived as hateful, even when it does not meet the criteria of inciting discrimination or violence. A vague or overly broad understanding of hate could lead to individuals being wrongly prosecuted for expressing views that, while unpopular, do not constitute hate speech under international norms. The proposed amendment protects against this by limiting hate to malicious acts aimed at incitement, meaning that opinions, discussions or debates that do not meet the threshold would not fall under its purview. In societies with robust free speech protections such as Canada or Germany, courts have consistently ruled that incitement laws must differentiate between offensive or harmful speech and speech that directly leads to acts of violence or discrimination. This ensures that minority views, satire or unpopular opinions are not stifled. The proposed amendment provides much clarity to the bill by defining hate as a malicious act aimed at inciting others to discriminate or violence based on a person's protected characteristic. This definition establishes a clear threshold for legal action, aligning with international standards and ensuring that the bill targets genuine harm while safeguarding free expression. The lack of a definition in the current bill leaves the door open to misinterpretation and inconsistent application, which could lead to wrongful convictions and chill public discourse. The amendment strengthens the bill by providing legal certainty and ensuring the incitement is clearly defined. Amendment 11. I'm nearly finished, you'd be delighted to know. This is Amendment 11. There is not a standard definition for incitement. It is a major problem with this bill, the fact that hate, incitement, and incitement to violence and hatred. The definition should be robust enough to ensure that no one is unfairly convicted. The emphasis on irrational creates a great burden of proof. The amendment introduces a clear and some standardised definition of incitement and to be included in the bill, which is currently lacking. The proposed definition frames incitement as behaviour or communicates about a person or a group that creates a serious risk of discrimination, hostility or violence towards them based on their protected characteristic. By doing so, it aims to establish a robust legal threshold that ensures individuals are not unfairly convicted for incitement, while addressing harmful behaviours that genuinely threatens the well-being of others. One of the major shortcomings of the bill is the absence of the clear definition for hate, incitement and incitement to violence or hatred. This creates significant challenges for the interpretation and the enforcement of the law. Without clear guidance, law enforcement and the judiciary are left to interpret these terms, potentially leading to inconsistent applications and an increased risk of wrongful convictions. The absence of a definition for incitement leaves a grey area regarding what kinds of speech or behaviour are legally punishable. This can potentially criminalise legitimate speech, including criticism, debate and dissent, which should be protected under free expression. Ambiguous legal terms also make it difficult for individuals to know what constitutes lawful or unlawful conduct, which can chill free speech by creating fear of prosecution or expressing opinions. The opposed definition is designed to be specific and robust, focusing on behaviour or communications that create a serious risk or harmful outcomes such as discrimination, hostility or violence. This sets a high threshold that ensures that only genuine harmful acts which are likely to lead to real-world consequences will be criminalised. By introducing the concept of a serious risk, the amendment prevents overreach and ensures that the incitement laws do not criminalise speech that is merely offensive or provocative. Instead, they will target individuals that poses a genuine danger to individuals or groups. The definition covers both direct and indirect actions, including communications about a person or a group, ensuring that the harmful stereotyping, misinformation or dangerous rhetoric that leads to real harm is addressed. International standards offer guidance on the meaning of incitement and the thresholds should be applied. The European Court of Human Rights has consistently ruled that incitement must be clearly linked to a likelihood of imminent violence or serious harm. In cases like Erbakan v Turkey, the European Court of Human Rights emphasised that offensive speech alone does not constitute incitement unless it directly leads to violence or discrimination. The UN Rabbit's plan of action sets a high threshold for incitement, requiring that the speech or behaviour in question be directed at a specific audience having intent and be likely to lead to imminent harm. This approach is designed to safeguard free speech while addressing dangerous conduct. Countries like Germany and Canada have also introduced similar thresholds in their hate speech and incitement laws, ensuring that only speech that leads to tangible harms is penalised. For example, Germany's criminal code includes provisions that punishes incitement to hatred, but only when it is aimed at disrupting public peace or inciting violence. By adopting a definite aligned with these international standards, the amendment ensures that Ireland's legislation remains in line with global human rights norms, particularly in balancing the protection of individuals from hate speech and violence with the preservation of free speech. The emphasis on irrational emotion or opium, enmity and detestation found elsewhere in the bill creates a high burden of proof and could lead to difficulties in prosecution. While it is important to distinguish between rational criticism and irrational hatred, the absence of a clear threshold for incitement increases the likelihood that individuals could be convicted for expressing views that do not actually incite violence or hatred. The proposed definition seeks to protect individuals from unfair conviction by ensuring that the only actions or communications that create a serious risk or harm would qualify as incitement. This introduces greater legal certainty and prevents over-criminalisation by focusing on actions that lead to a serious risk of discrimination, hostility or violence. The definition ensures that laws do not disproportionately target minority vices or satire or political dissent. These forms of expression often provoke strong reactions but do not necessarily incite harm. Inclusion of a standard definition of incitement is crucial for the bill's clarity and enforceability. The proposed definition established a clear threshold for what constitutes incitement, ensuring that the only behaviour or communication that creates a serious risk of discrimination, hostility or violence based on a person's protected characteristics are criminalised. This amendment aligns with international legal standards and protects against unjust prosecutions while addressing genuine harm, offering a more balanced approach to incitement laws. I can